All right, back live with you tonight here in Focus, and thanks for staying on. Home Affairs Minister Dr. Motsoaledi and Director General Makhode have been slapped with a personal cost order by the Constitutional Court. This after it accused the department of failing to correct legislation which allows suspected illegal foreigners of being detained without a warrant. Motsoaledi joins us now for more on this. Minister, good evening. Good to have you, and thank you very much for your time. Judging by your statement this time around, it seems yourself you are quite despondent about how shabbily this litigation has been handled. In fact, you accept pretty much the findings of the Constitutional Court. How did this happen in under your watch?
Well, my guess is as good as yours, Thabo. It didn't happen under my watch because I was not watching it. It happened without my knowledge. I'm sure if you read the judgment from the Constitutional Court very well, the judges accept that. The judgment say they accept the fact that the minister was in the dark. Because if you are not told, how will you know? I'm hearing the question you are saying under my watch. You are now waiting for Newzroom. You are there sitting alone. I'm not sure if you start doing things that are not supposed to be done, whether your supervisor, they will say he was watching you. Because you are a man, you are an adult, and you have been given this program to run. So it's something that was out of this world. And secondly, as I say in the statement, all senior counsels who have ever gone to court in my name for the department, even if they were not appointed by me, they were appointed by the state attorney's office. They phone me and say, we've been given these cases in your department, let's talk. We either talk by phone or we hold conference via virtual, and we discuss step by step. We discuss the affidavit and the facts, because lawyers are trained in law, but I know the facts and figures in the department because I'm working there.
Right.
It does not mean that a lawyer who goes to represent you know everything. You have to sit with them and you go through them and you will tell them that, look, much as this is legally sound, but it's not factually correct.
Right.
That's what you do. Yes.
It seems though in this case the intention, as the Constitutional Court found, that in both instances this case was brought as an ex parte application, meaning that those who brought the initial matter in 2016 were not informed, and like yourself also were not informed.
Exactly. And that's why they call it ex parte, because the people who took it were not informed. So me too also.
What was the intention then of those who took it? Why would they approach it in such a manner?
I've got no idea. Honestly, I have got no idea at all. As I'm saying, your guess is as good as mine as to exactly what is at play here. Perhaps when we start doing an investigation and putting people for consequence management, maybe the true story will come out.
Let's come to the matter at hand. You, of course, come into the office in May 2019, if I'm correct, but this is a matter that dates back to 2016. It would have expired in 2018, even before you came in. But what is the real matter here around Section 34, subsection 1B and D of the Immigration Act?
No, in 2017, indeed, I was not in Home Affairs. The court declared Section 34(1) of the Immigration Act unconstitutional. And then they said Parliament is given 24 months to remedy this problem. Now, Parliament agreed with the minister then that this will be a parliamentary bill, not an executive bill. An executive bill is a bill that is taken to Parliament by the minister, meaning by the executive. But a parliamentary bill is the one that is developed by Parliament itself on its own, which was the case in this case. And Parliament went on with it. From the records I've seen, I think they met about 4 times. Unfortunately, the elections intervened. And when you are dealing with a bill in Parliament and the election intervenes, it lapses. It usually lapses unless certain things are done in order to keep it alive. But usually it lapses. And the same thing happened. Second Parliament came in. As I get from many MPs, they were also not aware of it. And me too, in the Department of Home Affairs, I was definitely not aware that there was an amendment to an act which lapsed. Basically, that's what happened.
Yeah, but it seems your department was aware, and hence the attempt to try and get these extensions at least 4 or 5 times. Why would they not alert you of this?
Well, obviously, because I'm the one who came in 2019 as a minister. Officials in the department have always been there. And yes, indeed, many of them were aware of it. But even when they went to court to try and remedy whatever, I was not told, because I did not sign any affidavit which goes to court. Well, in many cases, you write a confirmatory affidavit, allow somebody else to sign it, or you sign it yourself. In this case, I didn't know.
And what normally happens when a parliamentary bill lapses and there is a court order that says fix the bill?
Well, any bill, whether it's parliamentary or executive, if it lapses, the person who prepared it must apply to the Constitutional Court. You may be aware, Thabo, that that's exactly what I did with the electoral amendment, twice, by the way. We did that in the present parliament. This amendment of the Electoral Law 73 of 1998 to allow independent candidates to come in. You are aware that we failed to meet the deadline. Parliament could meet the deadline twice. And on each of those occasions, we asked the Speaker to write to the Constitutional Court asking for extension, and that's what happened. But in this case, nothing like that happened.
The courts, though, are seemingly saying that they have no power to give such an extension anyway, even if you did bring it before them.
No, the courts do give extensions, and you'll hear from them only after applying it. You are aware that in this electoral law, Electoral Act amendment, the court gave us extension twice, so they do give extensions. I'm not sure in this case what will be the reason, but you'll only know if they can't give that extension. You'll only know from them. I think in this case it's because you ask for extension before it lapses. You can't go after it has long lapsed and ask the court for an extension. I think that's what they were talking about. Because when they went to court, it had long lapsed. You don't go to court after lapse, a period that was given by the Constitutional Court lapses and ask for extension. Why are they extending? Because it's over.
Now, the big issue then here, Minister, and then we'll come to the cost issue, is that you have an act that would have allowed for what is called administrative detention of undocumented foreigners for the purposes of deportation. And the Human Rights Commission saying that what was actually happening, people were being, not the Human Rights Commission, I beg your pardon, human rights lawyers, saying that people were being detained for 6 months, longer even, without being taken to court. Is this still happening?
No, it's not. They were talking about that in 2017, that people were staying for 6 months. I don't know anybody who's, in terms of the law, Thabo, when you detain somebody for deportation, they must appear in court within 48 hours. And if you don't want to do that, they must be deported within that 48 hours. If the 48 hours lapses, they must appear in front of a magistrate. If the 48-hour lapses during the weekend, on the first court day, you have to take them to court. So I'm not sure what was happening then that people have to stay for 6 months.
How do you then take this personal cost order that has been put towards you, Minister? They're saying that they ultimately the buck stops with you. The Minister is ultimately accountable for the fulfillment of the objectives of his department and for the actions and failures of his officials. Yeah,
well, Thabo, that's the apex court. If they say so, what can I say? That's why I'm saying I'm accepting. That is the finding of the court. Their finding was that they are convinced from the facts I gave them that I did not know I was in the dark. But then, as you said, they said, look, but the minister is finally responsible for the actions of all officials in the department. He takes responsibility. Now, that is a judgment from the Apex Court. I just have to accept it, painful as it is.
There are others who are saying cost orders are problematic because then it makes the political heads fearful of exercising their duties because of fear that when they are taken to court, they are going to have to pay these costs at a personal level.
Well, it might be one of the consequences, but the other one might be to other ministers in terms of the statement that you are responsible for the actions of your officials. And so which means you might have to babysit them, meaning one will then have to be a manager every day so that something like this doesn't happen. I think that those will be the consequences, both of which are not really good for governance, if I might say.
Yeah. What's going to be the consequences here? I mean, the conduct, the court says it's unacceptable and deserving of censure. And I'm sure that would be your view as well in how you were kept in the dark about this. Would you say this is deserving of some kind of censure for the officials who would have been involved?
Well, as I've said, I've accepted the court ruling, and I can't accept one part of it and reject the other. I've accepted the whole ruling. And if the court says there must be censure, obviously, I'll be in contempt of court if I don't do that.
Yeah, but I'm talking now about the department processes. I mean, will there be censure in the department after carrying out your own investigations as to what actually happened here?
Yeah, of course. There has to be consequence management. I won't call it censure yet. I'll say it's consequence management. Every action that has happened, there ought to be consequences. And labor lawyers will advise us exactly what consequences must be taken, against whom, for what reason, etc., etc.
So now you have, 12 months to enact the new legislation. What is the process that is going to be followed that needs to be watched now?
Well, because it's no longer a parliamentary bill, it's an executive member's bill. I must take that bill. Anyway, we have already started even before the judgment. Look at the amendments that must be made, what needs to be corrected, with guidance from the judgment, of course. Take it through government processes like cabinet committees, and DG's fora, and state law advisors. Get a certificate, do an impact assessment from monitoring evaluation, then take it to a cabinet committee, which if it passes it, then cabinet will endorse it, then it will go to parliament to start being passed as an act.
And you believe that would be attained? Again, you've got a situation of an elections coming up. We know how elections got in the way of the previous bill. Are elections going to get in the way of this bill?
Well, we just have to make sure between ourselves and Parliament that it doesn't happen. The amendments are not that much. In other words, it's not like the electoral law amendment where you're amending so many things. So I think Parliament ought to be able to take it through. At any rate, I believe they must fall back to what the previous Parliament has already done. I told you from the records I've seen, the members of Portfolio Committee met at least 4 times. Obviously, during those 4 times, they had some discussions on what to do, so it can be taken from there.
Right. Any idea how much the cost order is going to be? You're paying 10% of that?
I've got no idea. I wish I did. That's why in the statement we say as soon as the tax bills are from the lawyers for human rights are sent to us. What I know, as you saw in the statement, is the amount paid to this lawyer who was representing us, this senior counsel, and I've already instructed the state attorney's office to retrieve all the money from the individual, because the court actually said so, that whatever money was paid to this legal representative must be paid back to the state. That one I know, it was 222,000. I think 222,800 or something. But the one that the lawyers of human rights will charge, I don't know. All I know is that the judgment say not on a punitive scale.
Yeah, yeah. Big money is there.
They say personal cost not on a... Sorry?
I'm saying those are huge monies, 220,000. I mean, huge legal fees. I saw somebody suggesting on social media that there should be a fundraising campaign for the minister to assist him with these legal costs, because seemingly he's fighting for the nation all by himself.
I didn't see that. I'm humbled to hear that. There is that type of support. I'm really humbled. But in the final analysis, as I said, I've accepted the judgment. This is the apex court. You can't go anywhere else. You just have to do what they are saying.
I suppose, what are the lessons here then, Minister, that you are taking out of this situation going forward, that it does not happen again?
Well, look, even this is very difficult. Obviously, no one would like something like this to happen again. But I've been in Home Affairs now. This is my fourth year. And I've seen a lot of corruption, and we have charged people. We've dismissed a number of them. But this still keep on happening. People still keep on taking chances. I'm sure you understand what I'm trying to say. I'm saying the fact that people have been dismissed. Some 2 weeks ago have just been sentenced for 8 years imprisonment without the option of a fine after doing some corruption in the department. A large number have been dismissed. A few months ago, we demoted 2 people from the level of Deputy Director General to the level of Director. We demoted them 2 steps down because of shenanigans like this. But you never know what with human beings. So I can't sit here and say this will never happen again because it was not done by me. Anything that is done by me, I'll say, oh gosh, I will never do this again. But I'm talking about other human beings who have got other ideas and have got their own minds. All I can say is that if it happens again, we'll still take harsh actions. But I can't say it won't happen because in the first place, I don't even know why this one happened and how it happened.
Yeah. Are we likely then going to, when these things happen, we tend to see tensions between a minister and his DG? And this has also then ended up playing out in court because of decisions that ministers would take to try and deal with the DG. Are we going to see that kind of tension, or have you managed to resolve that tension with your Director General on this one?
Well, I've been in government for a very long time, since the inception of democracy. I've always tried my best to avoid tensions with the DG because the executive authority and the head of department or DG have to work together for the well-functioning of the department. I've never had such tensions before, I must say, except in a very, very few cases. I can only count one, if I'm not mistaken. But I try to avoid tensions as much as possible.
So, in other words, have you sat down with the DG to try and resolve this matter amicably?
Well, let that be an internal matter. The judgment was only on Monday. Let that be an internal matter.
All right. Minister, I appreciate your time. Thank you very much for coming on. That's Minister of Home Affairs, Dr. Motsoaledi, him alongside his Director General being slapped with cost orders for what the court calls lapses of extraordinary range and gravity. The court found there. More news after this. Stay